Welcome back. So we've looked at the positive integration side of the internal market's legal dimension, and now we're going to turn to look to the negative integration side. And this is embodied in a case from the 1970s, so early Court of Justice case law, called the Cassis de Dijon case. The case was brought by a French producer of blackcurrant liqueur, produced lawfully in France with an alcohol content of 15 to 20%, so French-style cassis. The producer wanted to sell in the German market, but there, that category of product had to have a minimum alcohol content of 25%, German-style cassis. The French producer challenged that German law in a German court on the basis that it breached what is now Article 34 TFEU, which prohibits measures having equivalent effect to quantitative restrictions on the free movement of goods. The case reached the Court of Justice of the European Union on the basis of Article 267 TFEU, a preliminary reference, on the question of interpretation of what is now Article 34 TFEU. We're going to look in more detail at Article 34 TFEU next week. For now, let's concentrate on how the court's approach in that case creates the conditions for the single European market to be created through litigation rather than by the process of adopting legislation. So it's probably useful for you to get a copy of the judgment to hand. There's a link on the slide, and I'm just going to get my copy here. It's a very short judgment. It only has 15 paragraphs. So if you have a look first, probably the place to start is paragraph 8. Paragraph 8. So if you look at paragraph 8, the court starts out by pointing out that there are no common rules on alcohol production and marketing. So there's no harmonisation at this time on this topic, either full or minimum harmonisation. In the absence of common rules relating to the production and marketing of alcohol, starts paragraph 8. In the absence of those common rules, it's for the member states to regulate matters concerning with production and marketing of alcohol on their own territory. But then the court goes on to say this: obstacles to movement resulting from disparities between the national laws relating to the marketing of the products in question must be accepted insofar as those provisions may be recognised as being necessary in order to satisfy mandatory requirements relating, for instance, to the protection of public health or the defence of the consumer. So Germany put forward a number of possible mandatory requirements that would justify its laws. These concerned protecting public health and protecting consumers. First, Germany states, if you have a look in paragraph 10, that its minimum alcohol rule is to avoid having lots of lower alcohol drinks on the market, because those lower alcohol drinks might induce a tolerance towards alcohol, which is bad for Germans' health. And second, Germany argues, if you have a look at paragraph 12, that its rule protects consumers from being taken advantage of by producers of lower alcohol content cassis, French-style cassis, which is subject to lower tax rates. Low alcohol liquor may secure an undue competitive advantage as it can be sold for less, thus misleading consumers. The court rejects these arguments. Have a look at paragraph 11. The court points out that lots of alcohol available on the German market is consumed in a diluted form with a mixer, and anyway, a range of low and moderate alcohol content drinks can be sold lawfully in Germany. And if you look at paragraph 13, you will see that the court says that fairness to consumers is indeed important, but it can be achieved here by labelling cassis with its alcohol content. French-style cassis does not have to be banned in Germany in order to achieve this. And if you look at paragraph 14, the court gets pretty close to saying that this rule is simply trade protectionism. It's not really protecting consumers or public health. So the court then concludes in paragraph 14, a bit further down in paragraph 14, there is therefore no valid reason why, provided that they've been lawfully produced and marketed in one of the member states, alcoholic beverages should not be introduced into any other member state. This is known as a rule of mutual recognition. The regulatory framework that applies to lawful production of goods and services in one member state must be recognised in another member state. But actually, this goes even further to a home state rule principle, where in effect, goods lawfully produced and marketed in one member state should in principle be admitted for sale in any other member state. So the consequence of the Cassis de Dijon case is that Article 34 TFEU must be interpreted to cover a rule fixing the minimum alcohol content of products that can be lawfully sold in one member state, Germany, the effect of which is to prohibit the importation and sale of alcoholic beverages lawfully produced in another member state, France. If you have a look in paragraph 15, you will see that's the conclusion. Given the supremacy of EU law, Article 34 applies in preference to the German rule, which must be disapplied. Article 34 is directly effective and can be enforced against an emanation of the state, here the German authorities. This is groundbreaking stuff in terms of the legal contours of the internal market. Reading the parts of Cassis de Dijon together, we can see the following implications. The effect of Cassis de Dijon is to remove the dual burden from producers seeking to market their products in more than one member state. Rather than having to comply with two different sets of regulatory requirements, two different labelling rules, two different composition rules, and so on, producers need to comply with only one. Regulatory requirements add costs, so there is a benefit in terms of economies of scale, the promise of the internal market, and there's a benefit to the consumer in terms of lower prices. If the member states do not like the outcome, for example, if there's what's called a race to the bottom, where producers set up and make their products in the place with the lowest regulatory requirements and then market to the whole of the EU, then the member states can use the EU's legislative framework to adopt EU-level legislation that secures an acceptable level of regulatory protection. Lots of EU internal market law is in this vein, especially its consumer protection legislation, some of which you should have studied in Law of Obligations last year. The principle of mutual recognition implies a degree of mutual trust between member states. In effect, member states relinquish regulatory control because they're required to accept regulatory standards, processes, and outcomes that are put in place by any other member state. The creation of the internal market by home state control is a powerful legal tool, but it will only work if member states have confidence in each other's regulatory mechanisms. Second, the approach in Cassis de Dijon is potentially exceptionally wide, capturing all sorts of domestic rules that have perfectly good reasons to be in place. Potentially, it even captures rules that have nothing to do with the products themselves, like a rule that you have to drive on the left-hand side of the road could be caught by Article 34 TFEU. As we will see next week, the Court of Justice has in fact retreated from that implied position in its subsequent case law. Third, the mutual recognition rule in Cassis operates only through litigation, which is an imperfect way of making detailed policy decisions. Many traders, especially small and medium-sized enterprises, lack the awareness or the resource to bring litigation and instead adapt their products and services to the host state's regulatory requirements. This is the case not least because when contemplating litigation, traders don't know whether the relevant member state will successfully justify their rules as representing mandatory requirements necessary to protect consumers, public health, the environment, the tax system, the NHS, and so on. Because of this, the European Commission has proposed, and the EU legislature has adopted, a series of mutual recognition legislation. The latest, a regulation from 2019, requires member states to respond administratively to a mutual recognition declaration, which asserts that a product has been lawfully produced according to the requirements of the home state. This attempts to move the practical aspects of relying on the mutual recognition rule from economic operators onto national authorities. There's more information about this on page 679 to 680 of the Craig and de Burke book. Furthermore, member states are obliged to give information on national rules that might impede free movement. Under Directive 2015-1535, the Mutual Recognition or the Transparency Directive, member states have to let the European Commission know before they adopt any legally binding regulatory standard, unless they're simply adopting a European or international standard set by a standard-setting body like CEN or CENELEC. There's more information about European and international standards, again, in any of the good textbooks. The Commission lets the other member states know and considers whether there should be an EU-level harmonisation directive on the issue at hand. As you'll have seen in the electronic workbook, the directive is important because according to the CIA security case, a national measure that has not been notified as required under the directive cannot be relied upon. Just pausing for a moment and thinking here about the Brexit perspective to all of this, the European Union isn't the only context where law is used to create a single market. In fact, the UK is currently doing this in the form of the Internal Market Bill, which is currently in the House of Lords. The UK needs to do this because some of the powers that are currently shared with the EU have to be repatriated to the UK, and they will be repatriated to Northern Ireland, Scotland and Wales, rather than at UK level, given the powers of those devolved nations or administrations in UK domestic constitutional law. In order for goods and services to continue to be able to circulate within the UK, where they currently do so on the basis of EU law, the UK needs to make provision for such a UK internal market. A single UK market is also important when it comes to the UK negotiating trade agreements with other countries, such as the USA, which will want to achieve access or to seek access to the whole of the UK market. The UK Internal Market Bill uses a different approach to EU law in 4 respects, as Kenneth Armstrong explains in a recent blog for European Futures, and I've put the link for the blog in the slide. First of all, the bill uses what is essentially a country of origin principle. If a product is lawfully sold in England, any regulatory requirements, say in Scotland, that diverge from the English requirements could be applied only to Scottish producers. Secondly, EU law has a strong but a rebuttable presumption that goods placed on the market in one state should be permitted access to the markets of other states. That's in the Cassis case. The presumption can be rebutted by reference to mandatory requirements, proportionate good reasons for the rules. The UK Internal Market Bill has very, very limited such grounds, only disease and pest control and the movement of unsafe food. Relatedly, and as we will see as we go through the rest of the module, EU law uses the proportionality principle to balance the different interests at issue. For example, as Kenneth Armstrong says, when the minimum unit pricing for alcohol regime was challenged by the Scots Whisky Association as a breach of EU law, what protected that regime in Scotland in the end was an acceptance that there was no less restrictive means of seeking to attain the public health goal set by the Scottish Government. Under the UK Internal Market Bill, there is no equivalent proportionality test. And then fourthly, the UK Internal Market Bill differs from EU law because it draws its net less widely than EU law in terms of which measures fall within its scope. If the measure only indirectly discriminates against products produced in another part of the UK, then it will be caught by the Internal Market Bill only if it has significant adverse effect on competition within the UK internal market. If there is a significant adverse effect, the devolved nation or administration can rely on a limited set of legitimate aims, such as public health protection, to defend their regulatory approach. This list of legitimate aims is less wide in scope than EU law, which includes consumer and environmental protection. One final thing about the difference between the UK Internal Market Bill approach and the approach in EU law is that it's not clear at the moment how the Internal Market Bill is going to be enforced and whether it is enforceable at all by private individuals. Whatever is the eventual position, we will have here within the UK an example of interlegality within a state, but one that draws on the concepts of mutual recognition and so on, from transnational law.